Welcome to today's webinar on the Respect for Marriage Act. Our guests today are Christopher Wolfe, Associate Professor of Political Science at the University of St. Thomas, Houston, Arina Grossu, Founder and Principal at Arete Global Consulting, and a Fellow of the Center on Human Exceptionalism at the Discovery Institute, and Phil Tran, a Personal Consultations Fellow with the National Catholic Bioethics Center. I'm your moderator, Phil Cerrone, an Associate Ethicist at the NCBC. The Respect for Marriage Act expands on federal laws and court decisions that shift the power of determining how marriage fits into the public morals from the states to the national government. The RMA reverses key provisions of the Defense of Marriage Act, redefining marriage, requiring state and local governments to recognize all marriages granted in other states, and creating a mechanism for individuals, organizations, and states to bring civil action against persons who violate the act. Moreover, the RMA's language suggests that it applies to businesses, individuals, and nonprofits, raising potential conflicts between religious freedom and equal protection rights, especially for Catholic healthcare and social service organizations. Today, our guests will discuss some key provisions of the RMA, its background, and its potential legal, political, and social ramifications. Thank you very much, Chris, Arina, and Phil, for joining us. Chris, why don't we start with you? Just go over some of the, what does the RMA actually say, and what are, some of the, significant legal and political effects that it might have?
Right. So maybe a precursor we might look to would be the Windsor case. That case initially ended some of the DOMA provisions, which at the federal level, DOMA gave the definition of marriage as being between one man and one woman, and it also, another provision of DOMA said that if one state has a certain definition of marriage, that definition will not domino effect to the other states, basically. Okay, so the domino effect to the other states no longer became relevant after the Obergefell decision. So what more does this Respect for Marriage Act do? Well, it changes the official definition for the federal government, and so there are provisions in it that say, well, this will not affect religious liberty, but I think that's what we're here to try to find out. Have the lawyers who disagree with a church organization's the way they see marriage, have we handed them a weapon to the lawyers to sue those organizations? And that's maybe just a broad way of starting, and the question that I have and that we can discuss.
Okay, before we go on, could you say a little bit more? You said the domino effect. What is this specifically?
Sure. So in the Constitution, they have, the Article 1, 2, and 3 on the legislature, the executive, and the judicial branches. But then there's the full faith and credit clause in Article 4, and that's the section of the Constitution on the relations between the states. And so in Article 4, it says there will be full faith and credit for the public documents in one state. Those will be honored in another state. So if you think about a marriage license, but in that there's an unless, there's a clause after that where it says unless otherwise specified by legislation. And so DOMA was legislation that said, well, this is going to be an exception. And so that's what I mean by domino effect, that for a while there in the early 2000s, we had some states who were adopting the traditional definition of marriage as between one man and one woman, California, even of all places. And and then other states were adopting the definition of marriage that the Supreme Court has basically imposed, which is that it's just two consenting adults, can be same sex. And so that's the what I meant by domino effect.
Great. Also, one thing with the Respect Marriage Act, as opposed to say what came out of Windsor and Obergefell and things like that, it seems to broaden the reversal of DOMA with language that suggests that businesses, persons, and nonprofits will all have to treat these marriages the same. So, what are some of the concerns that this raises for Catholic entities, and how is this, thinking about what might happen in the future? How is that affected by rulings such as Fulton v. Philadelphia and Hosanna Tabor v. EEOC?
So those are the some free exercise cases, and we have some protections that have been given. In the Fulton case, it was an orphanage, a Catholic orphanage, and they said we are not going to place children with homosexual couples, and they invoked the free exercise clause, to say, but and they won the case, and so we have these strong free exercise cases that have been coming up, especially in the current court. But here's one question that will come up now with this new law, Respect for Marriage Act. There have been some judges who have said that those religious freedom protections, under RFRA at least, only would not apply to private entities. They said, well, RFRA, it's just when the government does something, can you use that defense? And so this involves another case that might come up, which is the Bob Jones University case, where a university had a racially discriminatory policy, and then the IRS said, well, we're going to change your tax status. And so in that case, it comes up, is Bob Jones University a state actor because they accept money from the federal government? And they said no there, actually. So just because, Catholic Charities accept some federal money, that won't probably affect them. But that is, I think, one of the big questions, moving forward. If we do have, in some, especially more liberal states, if we do have some fines and some penalties that get applied to organizations that disagree with the definition of marriage put forward by the court in Obergefell, will they lose the tax status? Will they be fined? And can they use RFRA? Can they use RFRA as a defense? And so that's one of the big questions here.
Okay, so just to clarify real quick, before we move on. So one of the big concerns, if I'm correct, is that religious entities in certain states, in states that want to enforce a broader definition of marriage, these religious entities may no longer be able to operate if they don't treat same-sex marriages as marriages for purposes of adoption and things like that. Is that correct?
That happened in Massachusetts. It did. And they wanted to do that in Philadelphia, in the Fulton versus City of Philadelphia, but they were able to use a free exercise defense at that point. And so that is, a bit of an existential threat, you might say, to continuing the charitable mission of the Catholic Church in these areas. And so another interesting topic that comes up with this is, well, how are you defining what a church is? Which activities from the church get the free exercise protection? There's actually good news on that too, in terms of from the Supreme Court and the way that church activities are defined. It is not just freedom of worship. It is a free exercise of religion applying to many activities. In terms of the internal decisions that a church makes, those are very protected now under Hosanna Tabor. That's a strong precedent on the free exercise side of things. I think it's 9-0.
You started out by mentioning Windsor and Obergefell, and these seem to get to some extent to a conflict between state and federal rights over reserved powers that the RMA seems to perhaps be bringing up. So can you first kind of talk a little bit about that conflict, and then also an interesting point that has been raised is that you've been talking about conflicts between individual rights, conflicts between state rights, and so there seems to be a high likelihood of constitutional challenges, and they foresaw that in the legislation, correct? And wrote in a severability clause. So if you could, talk about those two things, kind of this, this conflict between, state and federal rights, the three things, the conflict between individual rights and free exercise, equal protection and free exercise rights. And then the fact that the people who even put this together knew this was going to be a problem and tried to insulate the legislation a bit from it.
Yeah, I'll just read the severability clause real quick. It's just one long sentence. If any provision of this act or any amendment made by this act or the application of such a provision to any person, entity, government, or circumstance is held to be unconstitutional, the remainder of this act or any amendment made thereby or the application of such provision to all other persons, entities, governments, or circumstances shall not be affected thereby. So that is, that's smart, because there's several provisions in this, and they know some of them are going to be challenged under free exercise. And so if one of them gets struck down, we don't want the whole thing to get struck down. And so part of it does just apply to the federal government, a change to the federal code in terms of the definition of marriage. But then you're right. Part of this will affects the full faith and credit clause, and that involves the federalism issues. Do I expect a federalism challenge to this? No, I would expect a free exercise challenge to this law. What was interesting with Windsor was that actually was a federalism case. Is it appropriate for the federal government to come in and issue its own definition of marriage between one man and one woman? And of course, in a way, the court came around and did that exact thing in Obergefell. So it's probably not going to be a federalism challenge to this, but I would think a free exercise challenge.
All right, and before we, close up here a little bit, talking about some of the effects of the Respect for Marriage Act. It gives a lot of people a lot of ways to bring lawsuits. And we've talked about this, we've talked about that, these constitutional challenges ultimately are lawsuits. So, say a little bit on this enforcement mechanism and on, what it says and where you see it going.
Yes, so I mean, um, there was a prediction made, at the end of Obergefell saying, this won't, religious groups won't be sued under this. And of course, we turn right around after that, and we have the Jack Phillips case, and Colorado prosecuting someone for not doing the wedding cake for the gay couple because he says it's against his free exercise of religion, and to have do his business, his art, for ceremonies that he agrees with. And so that actually, I mean, in some ways that we can see, look at Anthony Kennedy. Anthony Kennedy does all these big, same-sex marriage cases. And the very last in the very last year of his term, of his tenure, he does the Masterpiece Cake Shop case, and he says, no, I mean, I've voted on the pro same-sex marriage side this whole time, but this does not allow discrimination against religious people. And I think that they've been discriminating against Jack Phillips. And did that Masterpiece Cake Shop case end these kinds of lawsuits? No, they've continued to sue Jack Phillips. And in fact, we have another big case, the 303 creative case, where instead of a free exercise defense, it's going to be a free speech kind of defense, which was also seemed to be a possibility pointed to in the Masterpiece Cake Shop case, that might be another way to argue the case. So no end in sight, it seems like.
All right, thank you, Chris. We're going to move along to Arina Grossu. Now, Arina, Chris just gave us the nitty gritty. Here's the cases, here's all of the case law, here's what's going on. Unpack that for us. You spent time in the Office of Civil Rights under the Trump administration. You got your finger on the pulse of what's going on the social and, outside, kind of parts of things. So bring this around, tell us what's going on here.
Sure. So just to kind of bring it back in historically, this iteration of the bill was reintroduced on the heels of Dobbs versus Jackson, from that was in front of the Supreme Court in July, and the Justice Clarence Thomas actually said that Obergefell should be reconsidered. I think that got the Democrats scared and wanted to codify Obergefell through the passage of RMA. And so it was reintroduced soon after that. And one of the things that we should note is that law is a teacher. And imagine the equivalent of codifying abortion into federal law. We didn't do that, right? It was that there was a Supreme Court case, Roe v. Wade, and then there were the state laws. But in this decision, that's exactly what's happening, and what happened. And it got passed with bipartisan support, sadly, on December 13th, 2022. And one of the interesting parts that y'all may wonder is, how did Republicans, or why did Republicans go along with it, right? That's a huge question. And in fact, there were 39 House Republicans who voted in favor of the act, 11 Republican senators who voted in favor. And I truly believe that they were hoodwinked under two different areas to support this act. The first one is that it has a provision against polygamy. So that sounds like a great thing to include in there. And of course, it actually says marriages between two, but what if that definition changes? It wouldn't take very much to amend this law. And secondly, it has, and this is where I think a lot of the Republicans fell prey to it, it has the provision on religious liberty and conscience protections, which, as we heard from Chris, they could really just, it's just a facade in many ways, because any of that could just go away. But I did want to read a little bit about, so from, just so that you all have a sense of how it was worded. And so this is actually from the text of the act. It says, no impact on religious liberty and conscience. Nothing in this act or any amendment made by this act shall be construed to diminish or abrogate a religious liberty or conscience protection otherwise available to an individual or organization under the Constitution or federal law. And it says, consistent with the First Amendment to the Constitution, nonprofit religious organizations, including churches, mosques, synagogues, etc., and including any employee of such organizations, shall not be required to provide services, accommodations, advantages, facilities, goods, or privileges for the solemnization or celebration of a marriage, etc. And in looking at some of the Republicans' reactions to this component, Representative Owens said, today is undoubtedly a giant step towards religious liberty. So it seemed like they kind of piggybacked on that portion of it, even though it has all of these other ramifications. It was just a way to get this codified. Whereas others, like Senator Cornyn, said that he thought it was completely unnecessary since Obergefell already existed. One other part that y'all should be aware of in terms of the dynamic when all of this was argued is that marriage was put and couched under civil liberties based on sex, race, ethnicity, national origin, etc. And so essentially, these members of Congress, if they voted against it, people could say, oh, you're against interracial marriage, not just you're against same-sex marriage, or that this should not be codified into federal law. And so, and actually Representative Scott Perry, I'll read a quote that he said. He indicated that his favor of the bill in the beginning was a mistake. But he said, this is, and I quote him, I knew I had a choice between voting against traditional marriage or voting against interracial marriage. So talk about messaging, right? Whereas if the Republicans just said, we're not going to codify this into law, Obergefell could, just like Roe, be overturned. They should have stuck to that and looked at the precedent of how, even when there were quote unquote protections for religious liberty, in fact, those were just veneers. They weren't really there. So it's an interesting dynamic of what we saw happen there during the time that it was being considered. But I think that we have to go back to the fact that law is a teacher. And so what does this say about where we stand, right, as a nation, when we see that? Oh, and one more piece of information. So the Mormon organization as a whole supported this, and there were other liberal religious groups that also supported it. And so we really have to push back on that. Other groups included the Episcopal Church, the Evangelical Lutheran Church, Union for Reform Judaism, Reformed Church of America, United Church of Christ, and the Presbyterian Church. And so it also had the support of some of the liberal churches. But what we have to do is show that really that this is also a slippery slope, because there's nothing really to stop it from going into other areas like polygamy, etc. And it puts us in a very bad situation. Having worked at the Office for Civil Rights, and actually just yesterday, we helped groups file public comments on this conscience rescission. It's a regulation that, so I was there during the Trump administration, and we actually put out the most robust regulations to protect conscience in healthcare. there were 25 laws that and provisions that supported the protection of conscience. Well, since then, it's taken a few years, but since then, they not only, the Biden administration has looked at, right now, they're reorganizing the Office for Civil Rights. So basically the conscience division that we put there is going to be folded into the other divisions. But also the regulation that we put out there is they're rescinding it. But they still say in the regulation, if you look at the regulation, it says, oh, but we'll still protect conscience rights according to federal law, except that they've taken away the enforcement mechanisms. They don't actually talk about how the conscience laws that have been passed with bipartisan support are actually going to be enforced, or if money will be taken, federal funds will be taken away from entities that don't protect conscience. And in fact, they say that if you basically if someone's conscience rights have been violated, if they were to file a complaint, there's actually a chance that they could get that they would get in trouble, essentially, that there would be retaliation, because the line that the Biden administration is drawing, both with the Respect for Marriage Act and with, for example, this regulation, is, oh, there's civil rights that we want to protect, but also there's conscience or religious freedom rights. And so they're walking this line where they're trying to say that they're going to protect both, but that's not possible, in the sense that if you have a group that says my civil right was I was discriminated against because I wanted a same-sex marriage, or I was discriminated against because of my sexual orientation, and a group, a nonprofit or religious entity says, well, we cannot provide such services because of our religious stance. Those two butt up against each other, and they have not shown the way that they would defend, or that they even have any interest in defending conscience or religious freedom. And just to kind of show the direction where I think even with this law, it will go, as it is going with federal regulations, is that equity, the language of equity, is what's going to win out for them, which is everyone should be treated equally. This is the kind of way that they message. And so if you were to treat someone different because of their status, whether it's based on sex or race, or maybe even who they want to marry, then you are being discriminatory. So you're going to have again the conflict between the government saying that you're discriminatory versus your the protection of your own conscience. And so I think these are the types of debates that we're going to see and face coming out of this. But it's disappointing to see that why Republicans decided to vote for it, even though, of course, yes, they put in this language, but is it really going to be enforced? And the fact that they agreed to codify and change the terms of what marriage is in America, and really that there should have been a lot more pushback on that.
Thanks a lot, Arina. A question for you. You've kind of hinted a little bit here and there about it, but what do you see happening now in the next few months? With the passage of this law, with this related healthcare regulation update. What are some things that if you had to predict, you say we're probably going to see?
I think it's going to get very, very difficult for religious entities to continue practicing according to their faith and values. The proposed rule that is now, who knows, it might take 6 months to become finalized, for example. These things are codifying in regulations the kinds of protections that people, for example, who want transgender surgeries or abortions, or any kind of any kinds of those types of services, that those will trump religious institutions' right to conscience. And really the messaging line is, well, if you don't want to provide this, then you should step out of healthcare, for example. Or concerning the Respect for Marriage Act, or I see it going is, well, if you are in the business of marrying people, but you don't want to treat people equally, then you should step out of the business of marrying people. And this is to churches, etc. So I think that it's going to get very difficult because and this is why I think that groups should, especially in the healthcare field, step away from talking about themselves being as providers. This is the language that is in regulations. We are not just providers of services, right? Healthcare professionals are bringing their expertise, they're bringing their knowledge of, and also they're operating under the Hippocratic Oath, wanting to do no harm, to do what's right by the patient. They're not just providers of whatever the patient wants. In the same way, the church doesn't have to dole out things and be a provider of a marriage for whomever wants it. It's the same idea. And so it's the fact that we have to understand our identity as a church, and whether it's in the healthcare field as a Catholic church, or whether it's the church that gives the sacraments to people, right? That this is that we're not just a slot machine. And so I think we just need to get away from that language, and really at this point stand up for the fact that these institutions and entities operating based on their ethics, they must do that in order to be true to their identity, and it's not because of discrimination. And I think that's where we have to push back, because, for example, the church serves everyone, whether they have tendencies for transgender or sexual orientation, if they're gay or whatever they may be. It's just that when the church is kind of pinned in the corner to participate in these things that go against the church teachings. And I think that this is where we see that it's not just let us do whatever we want. It's we want you to sign off on it. Sign off on what we're doing, and whether or not it goes against your beliefs. So where I see it is that hospitals, and if we want to talk about Catholic hospitals, that they're a mess in many ways, because with the purchasing of various systems, etc., a lot of them have already lost their Catholic identities. So it'll be hard to argue, for example, on the healthcare side, that there's a conscience objection when they're already potentially doing abortions or giving out contraceptives, etc. So I think what we must do is the institutions that actually practice and want to live out according to their religious values need to stand up, and again, if their rights have been violated, to file the lawsuits, and to push back on these requests, whether it will be for them to do same-sex services, etc. So it's going to be an uphill battle, but the church has always had that, and it has stood apart. And so buying into that there are any protections was very dangerous. And I'll just equate it to the situation with Roe. Again, we didn't codify in federal law the abortion in the way that we did with Respect for Marriage Act, even though they're trying to do that now after post Roe, post Dobbs. They're trying to do that in many ways. But we just need to, law as a teacher, we need to stand up for what exactly we are the ethics of what this nation is founded upon. And I think what we're butting up against is when we live in a democracy where live and let live, let everyone do whatever they want. We're really, our democracy is based on an ethical people. So if we lose our ethics and our religious foundations, this is where we're going to see these types of issues come up.
Thanks a lot, Arina. And I'm really happy you mentioned law as a teacher, because that transitions very well into what Phil Tran will be talking about. And that's, this question of how, do you think, Phil, that the RMA is going to affect the cultural debate over these issues, over marriage, over things like that, especially when you see in polls and things like that, that even many Catholics, accept the broader definitions, even though the church and doctrine might be opposed to it. So how do you see, this law and similar laws affecting the wider debate?
Yes. Before I speak any further, I will just share that as an intern of the NCBC, I'm really privileged to be here, but my opinions don't necessarily express the views of the NCBC as a whole. So kind of with that, I wanted to tag along with what Arina had just stated, because that was the first thing that came to mind for me as well, is that law is teacher, and that the mores of a society are nurtured by public policy and cultural trends. And this forms the public conscience. So typically nowadays, and once again, I'm glad Arina mentioned this, that when people are trying to determine whether or not an action is right or wrong, they don't point to a notion of an objective good. They point to an action's legality. So once again, we can look at Roe, and so many people who have supported abortion, and when asked whether or not they believe it's a good or a bad thing, or if it's permissible, they'll say, well, like, essentially, or we as American people haven't adopted that the Supreme Court has already weighed on this. So we don't really need to think much further with that. So when people fail to think critically about the objective good or the morality of public policies, it's really easy for them, I would say, to fall into the mainstream way of thinking. And the majority opinion isn't always necessarily wrong, but it is subject to change with cultural trends. The government does a great service to the public when it affirms human law that is in accord with natural law and with divine law, because this does uphold the objective good. But on the other hand, it does a great disservice to the public conscience when it affirms false notions of morality that might already be present in the mainstream way of thinking. The public conscience, like individual conscience, needs to be formed properly, and this is largely done by law as teacher. And of course, we want the law to be a good teacher and to help rectify issues within the culture. So something that we see nowadays is that the culture, especially as it's been influenced by the media and public policy, is very sympathetic to same-sex unions, and these polls reflect that. And if we are going to be honest, the movements that are advancing this are very effective in winning over emotional support and even providing seemingly decent arguments to recognize same-sex unions and equate them with actual marriages. Codification of same-sex marriage will continue to affirm that sympathy, since people will point to its legality as justification for their views in favor of it. And this is really hazardous to an authentic understanding of marriage, which is, of course, a free, total, faithful, and fruitful covenant between man and woman. So as Catholics, we believe in the dignity of every human person, including those of our brothers and sisters who are struggling with same-sex attraction. However, we also believe in the dignity of marriage, which has a teleology or a purpose. So if we separate an authentic understanding of human sexuality and openness to having children, and we separate that from marriage, then what we're talking about is no longer marriage, actually. And same-sex unions aren't immoral because we don't believe that individuals with same-sex attraction are not capable of love. Actually, quite contrarily, the church upholds the idea that everyone has an ability and a call to love, but our society has a very skewed understanding of love because its understanding is hypersexualized. I think probably all or many of us know already that authentic love is simply willing the good of another person. So same-sex marriage is not is immoral and not marriage because its ends do not meet that of marriage, namely, a properly directed romantic love that is capable of naturally procreating children. And I think the other interesting observation is that it's really easy, I think, for Catholics to shrink in the face of an increasingly hostile culture that is advancing same-sex marriage. But we should keep in mind that our belief, as well as the belief of many reasonable people of goodwill, is actually the most sensical and reasonable because it has those ends of marriage in mind. And I think that those who are especially familiar with Pope John Paul II's theology of the body would know this very well. Another thing I'd like to point out is that it's one thing to support non-discrimination policies for all people. As I alluded to earlier, Catholics are all called to love of neighbor, regardless of whatever particular struggles he or she may have. And we do a great disservice to the world's perception of us if we legitimately discriminate or fail to welcome into the church individuals with same-sex attraction who do want to live a chaste life and a life in accord with the church's moral teaching. However, it is another thing to support marriage equality for individuals with same-sex attraction. And although we very colloquially use the term same-sex marriage, we have to remember that this construct is not actually marriage, right? In other words, we cannot treat same-sex marriage as marriage because it is simply not that. What I believe in these high-profile cultural debates surrounding same-sex unions and this opposition to religious and conscientious objection is something very indicative of an issue within Catholic identity and Catholic catechesis. So similar to how mainstream trends and lack of critical thinking have affected the American conscience, I believe that the broader culture has affected the Catholic conscience. A big challenge we see oftentimes culturally within the world is that not many Catholics, or even the majority of Catholics, have a good sense of what the church actually teaches. For example, you look at the 2019 Pew survey that demonstrated that only 1/3 of Catholics believe in transubstantiation, which is, of course, a fundamental teaching in the church. And of course, the world will look very different if this church of 1.3 billion baptized Catholics worldwide actually believed and lived their lives in accord with this creed, this common creed that we share. I would also say that human nature seeks the true, good, and beautiful. And I'm of the opinion that those who are leaving the church or those who choose not to enter the church are looking for substance elsewhere. And oftentimes they're siding with the mainstream way of thinking because of its apparent virtues. And I believe that one of the greatest challenges in the church is a failure to embrace our long established and extremely reasonable teachings and pass them on to further generations in a way that is substantial, but also attractive. When it comes to same-sex attraction, yes, we have to speak about it in a way that is abundantly charitable, but also unwavering in our belief about God's gift of human sexuality and the nature of marriage. And this involves living out our own relationships and marriages faithfully. I think a lot of people point to the fact that Catholics oftentimes aren't following Catholic teaching. They might be, aborting or contracepting or divorcing at the normal rates worldwide. So we should speak truth, but also demonstrate that truth is beautiful, even if it is difficult and requires much from us.
All right, thank you very much, Phil, on especially on that things on the living a Catholic life and things like the Respect Marriage Act, really indicating that Catholics can't cruise. It's that we actually need to live it and not just kind of go through the motions. Now we've got some time for questions. So if anybody in the audience has questions, please send them to National Catholic Bioethics Center there in the private chat. I'm going to get it started with a couple that we have here. And this is, for everybody. So whoever wants to answer, and all of you can answer if you want, but, what do you see as the best case scenario following the Respect for Marriage Act? And what do you see as the worst case scenario as far as, let's say mid to long-term outcomes? Arina, I know you got something on this, so why don't we start with you?
The best case scenario would be that the provisions that the Republicans fought very hard to have in there, the religious freedom, conscience provisions, would actually be considered, and that churches and religious entities would be able to practice according to their faith. But the worst case scenario is what we've seen happen, which is that these institutions are going to continue to be put cornered in the name of equity, or and actually be sued for being discriminatory against individuals who demand these services. So that's what I see, and really, given the state of, as I mentioned, where things are going, at least in healthcare, what I see happening is that the church is going to continue to be cornered in and say, you can do whatever you want and practice and believe whatever you want on your own time, but if it infringes on my rights, on my civil liberties, then step out of that. And so that push back and forth between religious rights and the rest is going to continue. That battle is going to continue. And one thing to mention is that, we bought into the right to same-sex marriage, which is just, it shouldn't be a right? It's not. We have human rights that have already been established, and so I think that what we need to do as an institution is to show that, one, religious rights and conscious rights must not be treated as second class rights, which right now they are. It's like, oh, well, they can take a step back. These other rights, even rights that we've created, even some within less than 10 years ago, take precedence over rights that have been in place since the beginning, since the foundation of America. Okay, right? The religious freedom, the right to religious freedom, to practice according, that's what America was founded upon. And so we have to really continue to show the history of why America even exists, and to protect conscience and religious freedom, and to show that, as Phil mentioned, that really to go back as Catholics to help to teach the public about what human dignity is and what marriage means, that it's not just a contract, that marriage is something more, and that it can't just be defined however we want it to be, that there's something in the way that we were created that makes marriage between a man and a woman, whereas the other things are unions, that civil unions, you might call them, unions that have been defined by the government and don't represent true marriage.
I think that Arina just put it very well about the best and worst scenario. And what that tells you is that those Republicans who voted for this were counting on the best case scenario, and they were taking a risk that perhaps this other worst, what about the worst? They didn't count on that. I mean, they were counting on the best case scenario. So to me, they took an irresponsible risk, because they may have comforted themselves and maybe some constituents by saying, well, this law won't really have any legal bite to it, because we've put this, conscience clause thing in here. But then, of course, we could have followed it up and said, well, how is that conscience clause going to work out in the law? And they said, well, we don't know. We'll take a risk, and so that's bad in itself. But it's also, of course, what both Phil and Arina were saying about the teaching aspect of the law was wrong too. So they took a risk in terms of real legal penalties, and they did wrong in terms of teaching something that they don't. If they're conservatives, they don't believe.
And that, actually, I'll add a little bit too about the fact that when Obergefell is overturned, and it will be, who knows, it might take 50 years. I hope it doesn't, the way that Roe did. Once you have something codified into federal law, it's in every nook and cranny of every law. And so another consequence of this is that this kind of language will appear in all aspects. And even when Obergefell is overturned, we will have to go back and take this out of that. And so it's a big mess. Whereas now, for example, with Roe overturned, since that wasn't the case, even though states had their own state laws regarding this, it definitely makes it more complicated when it's codified into federal law. I want to mention that.
I mean, you just look at all the remnants of segregation in the various states and laws. You see little remnants of segregation, and it took decades to get rid of them after the 1960s. And I think it's the same kind of thing. There's a phrase from Justice Cardozo about principles in the law. He says the tendency of a principle to expand itself to the limit of its logic. So there is no such thing as a slippery slope argument in the law. So there is no such thing as a slippery slope fallacy. Some people say, well, slippery slope arguments, those are fallacies. Well, not when it comes to the law. People will push it to the limits of its logic. People will do another lawsuit, a follow-up lawsuit. So it's not really a fallacy to make a slippery slope argument when it comes to things like this, I don't think.
Phil, you have anything to add to that?
Nothing else to contribute.
All right, I think we have time for one more question. And it's, given that the RMA has said that all of the states need to accept marriages conducted in other states, from a practical perspective and for the time being, is there any reason to have a definition of marriage from a practical perspective that's any stricter than the most liberal interpretation?
I don't quite understand the question.
So what I think they're asking is that, if every marriage performed in California has to be accepted in Texas and treated like a marriage in Texas, is there any practical reason, for, Texas to have a stricter version, a stricter definition of
to
marriage?
have its own definition.
Yeah.
I think there is a reason for exactly kind of the point that Arina pointed out about federal code gets into in every nook and cranny. Think about state law, same kind of a principle. It's not once again, since we do have the 14th Amendment, and we have so much power in the federal government now, and so much power in the Supreme Court, they wouldn't be able to, by changing like a Texas law to have the traditional definition of marriage, it couldn't trump the federal law, of course, but it still might be worth doing. Yeah. Teaching aspect, always the teaching aspect.
It's a comment. Oh, sorry, Arina.
One more point about that. So even though the RMA says that, so concerning polygamy, it says no federal recognition of polygamous marriages, nothing in this act or any amendment shall be construed to require or authorize federal recognition of marriages between more than two individuals. However, since the other part of the text says that, and as you mentioned, if for example, when polygamy will be accepted in one state, will the marriage of those three persons moving to another state, what would that look like? And these are questions that we will have to face, because it's the way culture is, it never stays in the same way. It's always pushing the envelope, right? Just the other day, I saw The drag story hour, they started with children who are middle school or elementary school, and now they're pushing it to babies, infants and toddlers. So it's always pushing the envelope. Well, what's pushing the envelope on this issue? It will be the polygamy issue. We already see articles about it, because if marriage is not between a man and a woman, then what's it to limit it to just two people? And so I think that's probably going to come down the pike, and I wonder if at that point they will just amend this law, or how they're going to deal with those provisions where a marriage in one state will be accepted in another state.
And the courts, sometimes they've acted like the tip of the spear in being these really bringing in the changes of progressive changes. And then other times they're kind of Janus faced, and they'll go back to saying, oh, we're not going to change anything. We just reflect the community standards that are already there. They flip back and forth between that. And they flip back and forth between that on the same-sex marriage issue. They were clearly the tip of the spear on the abortion issue. And then a lot of people started accepting abortion after that. But just know that sometimes they flip back and forth between those two things.